So we have, we're, I think, coming to the last panel session for the evening, and we've ensured that it is as interesting as it can get. We have a very, very esteemed panel here where all of the panelists don't really need an introduction, but I'm going to just take 2 minutes to do a quick introduction, and I hope I can do some justice to it. We have Mr. Vivek Sood, senior advocate, just written a very, very, very great book, best-selling called Chaff and Grain. Congratulations on that, sir. Fantastic work, and it's really, really enlightening for all of us. We have Mr. Pramod Dubey, senior advocate. I think he's the pioneer of white collar in the country, and has always led the way with, I think, initiating a lot of interesting judgments and doing a lot of great work that inspires young advocates like us all the time. We have Bharat Chugh, who's, I think, the voice of reason for a lot of us. His blogs actually talk about everything that all of us think, and he just finds some way to articulate them beautifully. We have Mr. Singh Bindra, partner at CAM. I think all of us at one point have applied to him and didn't get through. So yeah, I'm glad to be on the panel with him now, finally get my moment with him. The topic seems rather wide, and as a panel, we've decided to channelize it to three key segments, which as a panel we thought were very relevant to today's time. The discussions would be around the abuse of process in white-collar crimes. Then we will move to cross-border investigations. And then, lastly, we will deal with internal investigations. So I'm going to start the panel discussion with a query to Mr. Sood, or I mean, more of a question, just to understand that, there's a lot of propaganda on how there is an abuse of process, where criminal investigations are being abused by the enforcement agencies and the people in those agencies. So is that true, or is it just propaganda against agencies by people who are getting caught?
I started my practice in 1992. And, I used to do a lot of customs prosecution matters. And therefore, you have 108 of the Customs Act, whereby the customs officer issues notice to a proposed accused and gets his statement recorded. So we are going back in time, 1992, 93. Since I joined practice till date, investigation of white-collar crime or any crime, now today we are talking of white-collar crime, is totally unregulated. It is totally arbitrary. I have always said the IO, the investigation officer, is the god of investigation. He is bigger than the Supreme Court of India because there is no check. The law is well settled that no court will interfere in the manner of investigation. So therefore, he has absolute powers over the accused. He may call the accused 100 times at his whims and fancies. So this area is totally unregulated. It's not propaganda. It's not a contemporary problem. It's a long-standing problem. And the problem, I would address this problem, it's a colonial mindset of the investigative agencies in India. And I am not saying so. Arnesh Kumar, Supreme Court. The Supreme Court has said so time and again that investigation officers, the investigative machinery, the police suffers from a serious colonial mindset. And therefore, in my view, it needs to be regulated, and the only forum, the only platform where investigation, the arbitrariness of investigation can be regulated is by the court of law. So I think the time will come when you will have Article 14 in play, with respect to investigation of white-collar crime as well.
Thank you, sir. So it's interesting that you say it's colonial and the only forum that can actually safeguard the accused rights or the personal liberties of people are the courts. But Mr. Dubey, I'd like to ask you, just talking about what recently happened in the Supreme Court, if you look at the case of Vijay Madan Lal Chaudhary, what the Supreme Court has done has actually given those enforcement agencies unyielded, unfettered powers. So where does the problem lie? Like Mr. Sood said that, there are no internal checks. But even the Supreme Court at this point is, I don't know if I can go as far as saying, but they're sanctioning it. They're sanctioning this unfettered powers to the investigating agencies or the enforcement agencies.
First, I would like to thank to BW Legal and Ms. Sahni and all the audience. So far as the BJ Madan Lal judgment is concerned, I would say at threshold, this is the perception in the mind of the people at large. The Supreme Court has given so much power to the investigating agency and it is against the accused. No. If you read BJ Madan Lal judgment, you will find there is a lot of jurisprudence which Supreme Court has said in favor of the accused. Let us take the example of the presumption. There is a well-written judgment on the presumption. Number 2, what was happening if the accused is not named in the scheduled offences and he was being prosecuted for the commission offence under PMLA? The Supreme Court says once, first thing, accused is not named in the scheduled offence. Second, if the accused is discharged, acquitted and absolved, you cannot prosecute the accused under PMLA. So there must be commission of the offence in a scheduled offences. So the commission of the offences for the prosecution of the accused in the PMLA is sine qua non. Thirdly, the Supreme Court has said, if I have the property, I have obtained the property, if the property is not related to the proceed of crime and I have obtain the property by other means, you cannot prosecute me in the PMLA Act. So these all are also the plus point in the Vijay Lal Mandal Chaudhary, but unfortunately the Supreme Court judgment is altogether prosecution favoring judgment on the aspect the prosecuting agency like the enforcement directorate. They are not the police officers, they are not obliged to supply you the ECIR, they cannot maintain the case diary, and they have the unfettered power. And the most, I would say, most disturbing, I should not say it is the greatest respect to the Supreme Court. What we are coming across these days, whenever the matters pertaining to the economic offences, there is only one jurisprudence we are getting. The economic offences are spreading like the cancer in the society is cancer in the society. What is the cancer in the society? Your maximum punishment is 7 years. And you are putting the offence at a par. You are treating this offence as a more than, it is mentioned that the PMLA is the more severe than the offence of the murder. In the murder, the punishment is life and death. But you are saying the PMLA is altogether different aspect. And in PMLA, of course, there is abuse of the process of law. Even the investigating agency have started roving inquiry. The dispute is not connected. The transaction is not connected. But they are keep calling the person, asking so many materials. Recently, you must have come across, there is a judgment of Delhi High Court in Prakash Industry passed by Justice Yashwant Verma. And yes, Justice Verma has laid down the jurisprudence. If the transaction is not related to the PMLA, not related to the period in question, not related to the schedule offense, you cannot attach the property in question, you cannot go beyond the scope of the investigation. So the one thing is very important, and every day we are facing the investigation is, there is no end of the investigation. It's a roving investigation. They can call anyone. And unfortunately, what you are finding, they are increasing the number of the accused, which is not required. Even the person who could be the best witness, just to punish the person, you are arresting the person, bringing him in under the purview of section 45, where the twin conditions are there. Because now, after Vijay Madan Lal Chaudhary, the Nikesh Tarachand, the juries which was pro personal liberty, which has been already overruled. So, what you are doing, Section 45, you are depriving the personal from the personal liberty, and from the bottom to top, it is very difficult to get the bail. Though your conviction rate, you would surprise, since the inception of incorporation of PMLA Act, in the entire country, there is only one disposal of the matter. In last 21 years, there is only one disposal of the matter that was related to the wildlife matter. The schedule offense was wildlife matter, and that has been decided. I hope the second matter is going to be decided, which I have argued. There is no progress in the matter. They are filing the voluminous document. So, and what is we are also coming across, they are using the third degree. They are so humiliating the persons who are appearing. They are so scared entering inside their offices, and there is no check and bounce. There is nothing. There is no check and balance. No one is there to monitor. So we are going across a very bad phase these days. This is not a good phase for the defense, because mostly we are practicing, me or Sood. I know Bharat also, after demitting his office and getting the retirement from his offices as a judge. He was a very brilliant judge. He was a topper of his batch. He joined the defense also. We all are facing, because every day, and there is no consistency in the law judgment. If you come, every day you are finding the different judgment, and every forum, some high court has taken this different view, some high court has taken the different view. Even you see, the Supreme Court has passed the guidelines in Siddharth versus State of UP. I was privileged, I was the counsel in the Siddharth versus State of UP. On the basis of Siddharth versus State, they came good jurisprudence, justice call with jurisprudence and Justice Sundaresh in the Satyendra Kumar until. Despite Satyendra Kumar until, the Satyendra Kumar until and Siddharth versus State says, sir, if you have not arrested the accused, you have filed the complaint or the charge sheet without the arrest, there is no occasion to take the accused in the custody. But it is not being followed, especially in the state of UP, Bihar, Rajasthan. And it was so painful for Justice Kaul on 3rd February 2023 in Satyendra Kumar Until and Chandmal, Justice Kaul compelled to put his pain in the judgment by saying that despite our direction, the courts are not following, and this judgment should be placed before the judicial academies, and judgment should be taught to the judges. So it is, you cannot blame only one wing, because there is a relation between the bar, bench, and the system. So we are all the part of the system. There must be check and balance. There must be the accountability, and in the entire procedure, if you see, simply they have been written that the person would be taken action and they would be prosecuted. But have you heard any the IO or the prosecutor or anyone from the prosecuting agency has ever been prosecuted for the malicious prosecution? No. No. Till date, we have not come across any court has initiated any proceeding against any officer, and the officer has been convicted, or the departmental head has taken the action against all this. So there is no check and balance, unfettered right, and whosoever wants to do in their manner, there is no procedure. The procedure is only written in the CRPC, but they are not following the CRPC. Because when they suits, they say, we are only have to follow PMLA. When it's not suitable, they are saying, no, as per 65, you have to follow the CRPC. So there is no coherence, and God knows and what is going to next. Thank you.
Thank you, sir. So, Bharat, I'll move to you. While we're all extremely thankful that you moved to the side of the defense now, because I think the defense needs it more than anybody else. But, like Mr. Dubey was saying, that we're all a part of the ecosystem and we're all a part of the problem. But say tomorrow you have a client that comes in and says there's an ECIR against me, I've been summoned. I mean, by default, our default setting is we go to court, we get an interim order. But where does that balance lie? Isn't it also in our client's interest for economic offenses and investigations to expeditiously get over? But on the other hand, councils like us go to court, get a stay, get a no coercive action order, we get multiple, we cause an impediment in a sense. So how do you strike a balance now that you're on this side?
Uh, See that balance is difficult, but let me just take a step back and talk about this in a few buckets. Now, first is obviously the design flaws with the law as it stands. Now, Mr. Dubey very rightly pointed out some of those and some of the progressive developments also by the Honorable Supreme Court in the judgment that you mentioned. But I think there are serious problems with the law as it stands, number one. Now it turns the presumption of innocence right on its head. That's problem number one. To us as defense counsel, where we from day one are supposed to be proving our innocence before an investigation is completed, before we are given an opportunity to lead defense evidence. On day one at the stage of bail, we have to demonstrate that there are no reasonable grounds for believing that I've committed the offense. Now that's almost, and counsels would agree, an insurmountable burden or obstacle at the time of bail. Because I don't have the investigative prowess that the ED has. How do I prove my innocence at that stage? Especially when there is a presumption of guilt operating against me under the PMLA, where there is a reverse onus. Now, in many judgments, the Honorable Supreme Court has upheld those reverse onuses, but in my respectful submission, I think that needs to be re-looked at. And the high threshold for bail needs to be re-looked at. You know, when we have a system where 75% of people in the jails across the country are under trials, and with the conviction or acquittal rates that we have, I think it's absolutely unpardonable the way we look at bail. You know, bail is the rule, jail is the exception. We are taught in first years of law school, but I think that's where it ends for most of us and never translates into, you know, when we practice or when we adjudicate. So some design flaws. For instance, you know, the Supreme Court judgment says, and you know, in this setting we can discuss that constructively. Now the Supreme Court judgment says that an ED officer is not a quote-unquote police officer. Now, why is he not a police officer? And who is really a police officer? Now the proof of the pudding is in the eating, right? A police officer is somebody who investigates a crime. Not somebody who wears a uniform necessarily. So if you're investigating a crime, you have the power to arrest, you have the power to do a search, you have the power to do a raid, you have the power to freeze a bank account. You are a police officer. Now, whether you file a charge sheet or you file a complaint or you file a complaint that is taken under the law as a charge sheet, none of that matters. But any statement that you make to an ED officer is admissible in evidence against you. Now, when Indian Evidence Act was being discussed, or when they were laying it down back in the 19th century, they were mindful that we cannot trust the police officers to independently record accurate and correct statements. It is never going to be free and voluntary. Now that has been turned on its head on a very, very technical and specious ground, if I may say. So those are the technical problems. And with that law, where all the bets are against us, or all the, you know, defense counsel has such a difficult job, I don't see these interventions that we do as obstacles. Indeed, in some cases, an accused would have a vested interest in delaying the matter. For instance, if you know you've committed it and the investigation would reveal that you have, and there is clinching evidence on that count on the record, then of course you have a vested interest in delaying the matter, but not always. You know, I think we see, and that's how, you know, there are very, very experienced senior counsels here, that our job as defense counsels is to ensure due process, it's to ensure respect for human rights, respect for presumption of innocence, respect for speedy trial, not at the cost of a fair trial. You know, all of these things are extremely important, and in a more fairer system, in a more fairer law, in a more fairer jurisprudence, there would be less interventions. So if I'm entitled to bail as a matter of right, if I'm not a flight risk and I'm not going to tamper with the evidence, release me on bail. That would help me prepare my defense. And we would not have to be compelled to go to the higher courts asking for a stay on investigation or a stay on coercive process, or trouble the court every day with bail matters. These should be procedural matters so that everyone can get focused on the trial and how it works. And you know, not just the design flaws, there is also a problem of a judicial approach here. Now, we are taught in law schools, and this is the last point that I'll make before I hand it over to my brother. You know, we are taught bail is the rule, but if you go to trial courts across the country, and I've had the great fortune of, you know, being there myself and then talking to young judges across the country, there is a lot of conservatism in terms of grant of bail. Now, the law would tell you that you must grant bail, or you should err on the side of bail and not err on the side of jail. But then a trial court judge, and anywhere in the country, maybe situation is a little better in Delhi and some of the other metros, but a trial court judge would always be a little more conservative and would want to err on the side of denial of bail. And why? It's very human, it's very simple. It's like that bureaucratic, approach of not wanting to take a difficult decision, where there may be questions tomorrow on why did you grant bail in such a high profile matter? This is a 1,000 crore matter. Why did the trial court grant bail? But that's absolutely untenable. If you decide a case on merits, but again, if I argue for 30 seconds and take the brief of that trial court judge, have the higher courts done the bit to empower the trial court judge? Now, there is nobody more important in the criminal justice system or the civil justice system as a magistrate or a civil judge who can do all. He's got habeas corpus in section 96 CRPC. A civil judge on, at the district court level has got almost all powers to do even a mandamus in a mandatory injunction, bail. So, but we've not, for some reason, been able to empower them or basically attract, a talent or, retain it in some cases and so on. And these are broadly the reasons why a defense counsel would have to go to the court again to ensure a fair trial and due process. In an ideal system, it would be somewhat different, but we are there to, possibly, we have to be in the trenches to do our bit. So I'll just stop at that and hand it over to Juvraj.
So, Juvraj, I'm taking a bit of what everyone said here. Mr. Dubey spoke about how the number of accused in each case are increasing. Mr. Sood spoke about how unregulated the processes are. Bharat spoke about how, there are so many design flaws. But now, see again, I give you a situation where there is a client that's come to you. There are multiple layers in that organization. There are stakeholders, there are directors, there are employees, there are people in HR, there are people in legal who are getting summoned. You recently wrote about director liability in a WhatsApp group context. But I mean, how, again, you as a defense attorney or a defense counsel, how do you protect everybody and not, because, there is a mindset of at some point having to throw somebody under the bus. How is that balance struck with the systematic or infrastructural handicaps we all have?
See, let me play the devil's advocate, at least in my opening remarks. I know most of my co-panelists are really disgruntled, but nevertheless, you see, we have to be mindful of the fact that, the next decade for India, it'll be important. You see, the interplay between progressive capitalism and the rule of law is going to be very crucial. Now, most of what is discussed, including the Vijay Madan Lal judgment, any law which is read down, any law which is set aside, has to be understood in this context. However, that being the case, you see, progressive capitalism or rule of law cannot overpower at any point of time personal liberties, right? Now, by having said that, whether or not there are practical difficulties, there are practical hazards that we face as practitioners, whilst we are offering representational or advisory services, yes, we do. Finding a mid-path, navigating a mid-path is obviously a challenge. Now, to give you context, Bharat rightly mentioned, the twin bail condition. Most of us are only concerned for the latter, which is, the accused establishing his innocence at almost a pre-trial stage. The essence of that is that in the pre-trial stage, say when an ECIR is lodged, you see a copy of the ECIR is firstly not available with the accused. Now you have this new concept of a sealed cover, which we've, recently come about in most high courts. Mr. Dubey has a smile on his face. Now, and especially the money laundering statute, these are very complex allegations. It's a web of financial transactions. The allegations, the seriousness of it, the peculiarity of it is very, very complex. Now, the accused, whilst he already has, to prove his innocence at a pre-trial stage, which is completely the contrary to any adversarial system, you see, with the second handicap that follows is he does not have his documents. There is nothing available with him to be able to conduct that audit for himself internally, in turn to demonstrate it to the court. So that's the first challenge. Then the presumption of guilt. It's not that presumption of guilt was never available in any other statute. It was not postulated in any other statute. It's just that fortunately, unfortunately, money laundering as a statute has bits of all of this. And like what Mr. Dubey, remarked, It's not that the Supreme Court has sort of, laid down all of this. This was always there in the statute. They've only ratified it to a point. Now, let me give you another operational hazard. The accused generally are people running sophisticated businesses. The allegations against them, the legitimacy of the allegations have to be established subsequent to an adjudication. Now, today, in this background, they still have to run their businesses. To answer your question, there is what is the risk they're running? They're running the risk of several assets turning NPA. They're running the risk of employment loss, and there are several unsuspecting members of the public, several unsuspecting businessmen who perhaps are today doing business transactions with this accused, or are in a way intertwined with the web of allegations. I'll give you some context to this. So let's say, here is a land developer who's looking to develop an underlying land parcel which belongs to an accused. Now, despite having exercised every form of diligence, at the time of entering into that transaction, he was not in a position to ascertain these allegations by himself. Now, after the development agreement is entered into, he an ECIR is lodged, the land parcel is provisionally attached, subsequently confirmed, and is in possession of the ED. Now, today, there is a financial exposure on this land developer, right? There is a huge risk of employment loss. There is followed by, huge risk of, unsuspecting flat buyers who are either have invested in that apartment or are looking to invest in that group housing. You have the perils of RERA. You have the perils of several other, statutory regulators, chasing you. And all of this is in the background that the predicate offense, there is no charge sheet, perhaps no charge sheet, perhaps it has not been established. So, I made a note of 7 years, what Mr. Dubey pointed out. Now, 7 years, you have the reverse burden of proof. Whereas I don't think in 302, where there is life imprisonment, this burden is there. So, you see, when it comes to advising on, economic offenses, the challenges for practitioners are very different. The contours under which we sort of advise our client, whether to apply for a bail, whether to consider a 482, in terms of next steps, are, the assessment we do for them, the advices are nuanced by several factors. But this being said, you see, the balance kicks in when, like I said, now the next decade, India today is amongst the top economies of the world. There is an FTA coming about, the presidency of the G20. We have a robust government. Now, these deterrents are also somehow, part of that ease of doing business for anybody who's looking to invest in a robust economy. But where the balance lies is that these deterrents don't become a hindrance. Hindrance insofar as ease of business is concerned, hindrance insofar as personal liberties are concerned. Personal liberties discussed time and again, Puttaswamy, Khadak Singh, Maneka Gandhi. But, practically applying all of this, need hardly be said, is a challenge. But I'm sure, the government in its recent amendments and, is mindful of, the challenges which the business community is facing. And economic offenses, business is at the heart of it. So I would never argue that the intent of any legislature will be to hamper a business enterprise or the business sentiment at large. So we'll have to discover a larger meaning to it, and perhaps the legislature is also looking to discover that.
Thank you for that. So, you laid a lot of emphasis on pre-trial investigations or pre-trial homework that all of us need to do. I'm going to turn to Mr. Sood. So there's this growing concept of internal investigations, forensic audits, which law firms do, the top 4 accounting, consultancy companies, they conduct a lot of these investigations. With your experience in the trial code and the investigations that you undertake during cross, during chief, how important is the outcome of, say, an internal investigation or a forensic audit that a complainant may have conducted at their own end? Do courts perceive them well, or do they have a prejudice or a bias that, it's come from the complainant's end? What has been your experience with internal investigations in tribes?
In my view, private investigation has to be encouraged, because the police, the traditional police infrastructure in the country is lagging behind, the challenges of investigation in, say, cybercrime cases, or, white collar crime, or embezzlement, misappropriation. So therefore, private investigation, there is no bar. First of all, there is no bar under law. But, there has been too much of reliance, over-reliance on police investigation. Having said this, this is a new age that we live in. And private investigation will have to be encouraged. If proper, fair, honest, complete, scientific investigation has to come into play. Now, having said this, obviously, private investigation is not an absolute. It is not conclusive in nature. The court will separate the chaff and the grain. I keep using this expression time and again. It is not absolute. It is not conclusive. It's a piece of evidence. It can support the prosecution. Many times I come across complainants, litigants, briefing lawyers, law firms, and they are so frustrated that the police is not acting on their complaint, because the police has no damn clue as to what to do. In a complex cyber crime case, or in a complex white-collar crime case, they have no clue what's happening. So I suggest to them that you conduct your own investigation, place it before the investigative agency, and that has to be taken cognizance of. At least ultimately, even if the police, brushes it aside because of their colonial mindset, how dare you interfere in my domain, that attitude, at least it will be with the charge sheet. You can file it in the court. You can use 156(3). You can use Sakiri Vasu and some other judgments which say that the courts can, to some extent, monitor the investigation. They cannot control the manner of investigation. They can monitor the investigation. I am all for private investigation, especially in complex cyber crimes and other white-collar crimes.
Thank you. Mr. Dubey, what about you? I don't think it's fair to say, but like I said, you, Mr. Sood, are the pioneers and have started or led us to understand what criminal investigations really are. So is there a tryst with the traditional criminal investigations the minute this concept of private investigations have come in, forensic investigations have come in? Are not only the investigation agencies and the judiciary, but even at the council level, do you think there's a tryst that we are experiencing? Because that's not what we ever studied. We didn't ever learn about any of this. So this is absolutely new. So are we ourselves uncomfortable with it?
At the outset, I would like to share one of the experience where I got the occasion to work with Bharat, and in a matter. It was a multinational company, so the transaction was very complex transaction, and it took almost more than 2 months to prepare the criminal complaint, because we are not able to find out the criminality at the threshold, at the very inception, and we started doing our own investigation, examining the materials, all the materials. Ultimately, we got the clue where the offense has been committed and how the money has been siphoned off and who is the beneficiary of all these things. Based on this, ultimately we got success getting the FIR registered. We both are not doing the matter presently. So I have experienced the forensic audit or the internal audit are a very important tools, because the recruitment in the investigating agency, they are not well versed with the complexity we are facing these days, the kind of the crimes, especially the white collar crime, because you must be knowing the difference between the blue collar crime and the white collar crime. In blue collar crime, you have nothing to do, you just took out your revolver and shoot the person and commit the rape or the robbery or dacoity. So there is no problem. But in the white collar crime, it's a well systematic, well planned, well hashed the commission of the offense. So the expert would be in the better position. See, in Delhi, and we have the circular by the commissioner of police, if you have the litigation claim of the involvement of money to certain extent, like the 2 crores or 5 crores, that would be investigated by EOW. So why EOW? Because they have trained the EOW people to do the investigation for that kind, which is not available with the normal police station. So you'll find that there are so many problems comes into the investigation, like the person is a ASI, he has got the promoted to the sub-inspector or the inspector rank, he's not able to understand. His background is, suppose he's a humanities background or the psychology or sociology, he does not know the economics or the cyber things. You don't have any knowledge about your problems. So if you are giving your complaint is based on your internal audit, which is unbiased, the rider would be, the report must be unbiased, so that you are not going to confuse and prejudice the mind of the investigating. If you are supplying unbiased material with the investigating officer, that would give the light and the clue to the investigating agency to move forward. And the material which has been relied upon during the internal and the forensic audit, that could be the substantive piece of evidence, that could be the circumstances to find out the person who has committed the offense and who is actively involved in all these things. So this could be also the material which will help the case of the prosecution, and your internal audit would subsequently be merged with your complaint or the FIR. So there would be also the doctrine of merging. So I would basically in favor of doing the first your internal investigation, forensic investigation. You know whether the offense has been committed or not, and if it's committed, so who is committed. So you will be able to trace the layering or siphoning or traveling of the money transaction or the creation of the document, the forgery of the document, the conspiracy. So you will be very much clear, there would be transparency, and you will be in the better position to get the fair investigation if you are supplying. Even if you have the material and you have supplied the material to the investigating agency, they have ignored or being influenced with the other party. So you have the remedy which rightly been mentioned by Mr. Sood. We have a very celebrated judgment of Justice Markandeya, that's a Sakiri Basu. So Sakiri Basu is given the right to the victim to move the application. Earlier in the first round, Mr. Sood had said that there was a law that you cannot interfere in the investigation. It's the exclusive domain of the investigating agency. But Justice Kartu's judgment in the Sakiri Basu changed the old jurisprudence, and he says if you are the aggrieved person and the victim, you have the right to move the application under section 156(3) CRPC before the Ilaka magistrate. There is a concerned magistrate where the FIR is pending or complaint is pending, and the Ilaka magistrate can give the direction to police officer to investigate on every aspect which you have raised in your application. So there is accountability by way of the moving the application under 156(3) to the Ilaka magistrate. So once you have supplied the material, there is no investigation or there is no information to you, or the matter is going on for since long. So you can expedite, you can file the application. So I am fully in agreement that it is very important these days, the nature of the complexity, the transactions, the involvement of the so many parties. The internal forensic agreement, the audit are very, very, very necessary to strengthen the case of the prosecution.
Thank you. I know we're short on time, so I'm just going to have one quick question. So, Juvraj, I'll come to you first. You know, we're talking about how internal investigations are important because of the complexity of it. But I mean, from a client perspective, are people receptive to that? Isn't there an advantage in there being a complexity and it not being unraveled at a pre-trial stage? Isn't, if there wasn't an internal investigation, because the cops have a handicap of not understanding the nuances and complexity, isn't that something that could be used to the defense's advantage rather than putting it out in black and white? Also, the second aspect of cost. I mean, why, like, are clients receptive to internal investigations because they're rather expensive vis-a-vis just the police not charging anything?
See, the Indian companies in the last decade or so have, you use the word receptive. They are receptive, and they're sort of voluntarily subjecting themselves to internal investigations. I mean, the reasons for that are wide and varied. You see, in the last 10 years also, the laws in respect of governance and disclosures have also evolved. So there is an internal investigation compelled by law, and there is an internal investigation by choice. So there are two kinds of it. Now, you see, like Mr. Dubey pointed out, an internal investigation always preludes a statutory investigation. So you need to get your house in order first to be able to, go institute a complaint, decipher the allegations, because these are financial crimes, complex financial crimes, right? Now, typically the trigger point for an internal investigation is, you see, either there is a whistleblower complaint, or perhaps, you see, there is reason to believe that there is a violation or a potential violation of, say, an internal policy, or some anti-bribery laws, or some code of conduct, right? Now, an internal investigation, firstly, benefits the reputation of the company. I'll put it differently. So, you see, the disbelief in the public that perhaps there is some wrongdoing which is happening in this particular enterprise is immediately wiped off when, the company raises his hand and says, look, if there is a problem, I'm going to put my house in order. Now, this is also in the background that, there are some requirements under the Companies Act, and also you have the SEBI LODR. The threshold for a listed company is in fact more, because, there have been interpretations to suggest that listed companies have a public interest, because they have access to public funds. So therefore, the threshold for them is a lot higher, and the SEBI LODRs in fact also contemplate that for a certain threshold of fraud, if it is reported, it has to be immediately flagged for the attention of central government, and also the auditors internally have to sort of collate their report, etc. Now, against this background, clients are again receptive, I will reiterate, but they have to be mindful of who the client is when an internal investigation is being carried out. You see, that distinction for the privilege to follow, that attorney-client privilege to follow, has to be carved out at a very rudimentary level. You see, so the terms have to be set out at the nascent stage, so that, the witnesses, the interviewees are aware that you're either acting for the company, you're acting for the board, or you're acting for, say, the general counsel, or somebody who's a neutral party, neutral and, alien to the allegation and the offense at large. So that if tomorrow the client is looking to forego that privilege, it's like an upjohn warning. You've already raised that upjohn warning to the interviewee, etc. Now, this also enables the client to, in turn, sort of present that internal investigation or the forensic report to the investigating agencies, either in the form of a complaint or, an equivalent of that. So, and also, I'll just take half a minute. Also, you see, ESG is the buzz phrase now. And the background to it is understanding that, you see, a lot of integration within an organization is also important. You see, we have witnessed instances wherein most employees in an organization are not willing to sort of flag some sort of a non-compliance for the attention of the audit committee, or say for the relevant committee or their seniors, because there's no integration as such. So it's important that companies begin to understand, and they're already mindful of this, that creating that right environment, social, and for the employees in different departments to be able to report a wrongdoing in the background of a statutory governance requirement. So it works both ways. You are effectively empowering the internal department, and you're also conscious of your governance requirements under law. So that being said, internal investigations perhaps are paramount today. So, the balance, like you pointed out, the balance will automatically click in if your house is in order. When your house is not in order, then you will always point a finger at somebody else.
Thank you for that. So, Bharat, the closing question for this panel. I think the panel is at item that this is a pro-internal investigation panel. I think it's a pro-investigation regime. So, do you think it's time to institutionalize internal investigations, or is it too premature? Is our country ready for it?
I think two broad frameworks for the issue of internal investigation. Then very quickly, one is desirability, whether you need them, or is it pragmatic to be having them? Would they help ongoing investigations or prosecutions, or put proper corporate governance in place? The answer is yes, they're obviously desirable. On legality, of course, the CRPC, the other procedural laws that we have, even the Companies Act, they never envisaged a company investigating itself, to speak of it. And if you go back in time and you see how the internal investigation as a concept or as a discipline or a practice area start, this is when the Department of Justice or the SEC in US would want to look into alleged fraud in the case of a listed company in the US, for instance. And they didn't have the bandwidth or the people or the expertise to look into a complex fraud. And they came up with this improvised solution where they said, why don't you investigate it yourself and present to us the findings of what fraud or what accounting irregularity has taken place, and then we'll take a decision on it. So you make the accused look out for evidence itself against it. So, when you said that we are in near unanimity on the desirability, I'm doubting a lot here, to be very honest. And I'm not just playing the devil's advocate. There is a very serious conflict of interest at the heart of internal investigations. When the accused, when the suspect, a company who's been accused or who's being accused of having taken the shareholders for a royal right, you're asking the company to look within and be independent and objective and to collect evidence against itself. Now, I have my serious doubts. Now, in an ideal world where law firms, statutory auditors, merchant bankers, the other gatekeepers of the economy, or people who were in-house departments, or who were supposed to be the conscience keepers of a company or for the economy, and they were possibly doing what they're supposed to be doing. And this ideal situation, by the way, doesn't exist, and it hasn't existed, and I have my doubts if it would ever exist. So in an ideal world like that, possibly you can have the accused collect evidence against itself. But since we don't have that, and we understand that sometimes it may be needed. So, I'm more in favor of internal investigations, and I join suit with my learned brothers and seniors when, for example, the company is prosecuting. Now, the company is prosecuting complex financial fraud, complex cyber crime, a cryptocurrency fraud. The company, the IO would not know any of it, right? So the company does that with the help of IT consultants, the forensic consultant, puts together a watertight case, and then puts it to the investigating officer. Now you have a problem again. Now, no law, no CRPC, no Evidence Act says that an internal investigation report is either pending or even relevant or even admissible. Now, in an internal investigation, you may sometimes find a document, which may be the forged document. Now, that may become admissible when the IO would seize it in accordance with the CRPC in a search and seizure, and then makes a panchnama, puts it on the file, makes it a part of the police report, the judge takes cognizance, and then, you can rely on that document. But for example, any statement made to a law firm or a forensic or a big four conducting an internal investigation in the course of investigation is, I dare say, not even worth the paper it is on, unless it amounts to an extrajudicial confession. So how do you map onto all of these internal investigations that are currently happening? And it's a very attractive practice area for a lot of law firms. How do you map them onto the law as it stands today? is the ultimate question, according to me. And I think a long way to travel for our legal system to be rendered compatible with internal investigations. Let's have the legal regime in place, then do it right, then do it properly, and also fix responsibility on lawyers, on auditors, on gatekeepers of the economy to do their job well. And then maybe you'll have a case for internal investigations. Thank you.
Thank you so much. Well, I think it's safe to say that we've concluded that it is a terrifying time for white-collar criminal investigations, but I guess we defense attorneys have our work cut out for us, and I think we have a lot of work to look forward to. So thank you, everybody. Thank you for your time today, and thank you to the panelists for taking out time. Thank you.